Action for day lordship. The Mr. M. Ahmed is not available today. Hearing that
Item number 27.
27. Supplementary. List after action for day lordship.
Request made by the material action for the disseminate item for the day.
Deputy.
May I please? I beg to mention item number 24, my lord. Orders column, in orders column. We have taken a step on respond number 2, but no report has been. The report may have been awaited, my lord. And LCR was also called. It has not been.
24. Yes.
24, my.
I mean, respond number 2.
My lord.
Service is not completed.
Not. Maybe awaited, my lord. We have taken steps, my.
And the LCI is also not.
Not received.
As per of this note, the LCI as well as the service of the respond number is active. Issue reminder for this year. That this service be awaited till next list accordingly. We cannot fix a date. We'll list after 2 weeks.
The interim may be continued.
List after 2 weeks. Was the interim was
Yes.
interim be continued till next date.
Obligation.
May I please, Your Lordship, with the consent of the other side, I beg to mention item number 25, Lordship. The engaged counsel is not present before the Honorable due to his personal difficulties, Lordship, and they fixed it on 20th of March, Lordship.
The request made by candidate counsel for the petition. Relate. What you're saying at the main of
Lordship,
no, you're submitting something. What do you say?
engaged counsel is not, Lordship.
No, it's okay. Now regarding date,
Your Lordship may kindly fix it on 20 March, Lordship.
20.
20.
See to it. Okay.
Must open.
No, Saturday no part. Tomorrow we will do. Really, we have to meet. We didn't. We didn't. No brains. Let have you saw that you have to out. Second. We didn't. Yes.
Lordship, this is an anticipatory bail application in connection with Gauhati PS case 201/2025. The alleged sections consist of criminal conspiracy, extortion. Therefore, at this stage, CD may be called for, Lordship.
Just a second.
Yes, Lordship.
He delayed. Order. So, collect annual plus ISO of 6 3. No, no, তেওঁ যিটো কৈছে তাতে ছয় তাৰিখ The last occasion it was order was that the appropriate bench before appropriate.
Yes.
Most probably Justice Panjal Das was taking up these matters of same FIR.
Yes.
Now this is the administrative order from Chief Justice. Till 60 he is in Aizol.
Yeah.
Justice Das. So most probably matter is again.
Lordship, may pick call for the case diary, ma'am.
You can call for the case day.
Yes, only
Okay.
for the case diary.
Lordship,
Most
there is a
probably in
similar
that
matter.
case, your matter may be placed before Justice Panjal Das. Today we are calling for the case diary.
Yes, Lordship.
RMSP Bora and also have Mr. P board. Still an additional PPA bring on.
So, this one.
No.
Yes, when it can be called. Speaks.
My lord, on 19th of March, 18 of
19 will do.
Lordship.
Okay, listing it on 9.
Obliged, Lordship.
Well, in this case, one report was called for from the my lord, North Bongaigaon outpost and Bongaigaon police station. My lord. I am trying to get the instruction, my lord. Till now, I have not received the instruction, written instruction, my lord. Already petition, your lordship, any short date may be fixed, man.
You have not received the instructions.
Yes, my lord, written instruction. Ma'am. Because from North Bongaigaon outpost also, well, I tried to contact my lord. Now he is
And
contacting.
both I asked you to go from North Bongaigaon outpost
And
or Bongaigaon police station.
yes, yes,
Maybe
yes,
there also. Gauhati station may be there.
yes.
It is within Bongaigaon police station, but police is harassing us from North Bongaigaon police out.
Now, even if suppose North Bongaigaon police station, if any FIR is lost, that will be sent for registration to Bongaigaon police station.
Yes.
As per the norms.
Yeah.
So that's why I asked to inquire both in North Bongaigaon police outpost and the Bongaigaon police station. When it can
Your
be
lordship may fix on 10th or 11th, any date, my lord.
next
Next.
Tuesday.
Yes.
Maybe 10th.
Yes,
My lord,
then-
police is demanding rupees 30 lakhs from us.
So, yeah, so
So some protection,
then on 9th only.
9th, yes.
9th, Monday.
some,
We're fixing it on Monday.
my lord,
Fixing it on Monday then.
yes,
Someone.
North Bongaigaon.
Mr. Mr. Babu. Mr. Board. It is submitted by Mr. Board.
Very possible, my lord.
Communication with the concerned police station. No report is
No harassment.
submitted till date. And
Wait, no,
we
that
will
was-
the London petition will be hereby asked to take instructions of the report from the concerned police station on or before the next office. List a matter according to 9th of March.
Yes.
Right. Right, yeah.
May it please, your lordship.
Yes.
Lordship, the matter pertains to seizure of a cell phone of the petitioner without following the due process of law. Without any registration of cases, without any issuing any seizure memo, the phone was kept by the police with them,
Seizure memo is also not.
not issued. They are private respondents in the instant case. have lodged two cross FIRs against each other. And in that connection, Your Lordship, the petitioner was called to the police station. He was asked to hand over the cell phone and also asked to give the password. And when the petitioner refused, then they kept the phone and refused to return, and also not issued any seizure memo. No case was registered against him also. Just they were called for an inquiry even without issuing any notice. On the last occasion, instructions were asked to be brought, Your Lordship.
Actually, WBC criminal, my lord, government advocate.
Government was there, I think.
Last time.
Then they will have to inform.
But government advocate
Yes.
was not provided with any copy and all.
Your Lordship, on the last occasion,
Only DP Goswami, the additional PP was there.
Lordship.
He was provided with the extra copies and all, whatever. But government advocate,
And the matter may come up after a week, Your Lordship.
Okay.
whether you have taken any steps for notice also, no?
No, there was no order, Your Lordship, for taking steps on the respondents,
Only for the instructions. Was.
only for the instruction.
Yes, Bhattakur, only instructions was sought for
Yes, ma'am.
regarding that seizure of the mobile handset. From whom?
From the OC,
Officer in charge.
Officer in charge, Women Police Station, Panbajar.
Yes, ma'am. Then I will have to go through the order and try to get the.
Pardon?
I will have to go through the order, my lord, and get the instruction.
Yes, Mr. Kusami was there, and this there are other two other private respondents also there.
Yes, ma'am. Because my
We
lord,
can
PP,
issue notice also in that case.
Lordship, PP Assam was not made a party, man. Government advocate.
PP Assam is not a major party. So who will represent this state of Assam represented by the secretary? From the department?
Regarding from the my lord, report from the police station, I will try to get the instruction.
Because officer in charge is also a thing.
Because we are not a party, my lord. That is that I will have to, otherwise I will have to inform government advocate who is earlier.
Yes, it is a government advocate only.
Yes.
You are not the party also.
Yes, yes. I will intimate them.
Pardon, each Buraku.
Each Buraku.
Each Buraku. Petition.
Okay.
From the order dated 2302. It is in that the learned additional people will also take regarding confiscation of the mobile phone of the petitioner. But it is submitted by Mr. Bhattakur that the PP Assam is not made party in this case. And JA Assam is also not provided with any copy of the petition. In view of this, let the instructions from the concerned police station be awaited regarding confiscation of the mobile handset. At the same time, petitioner is hereby asked to take steps in issuing notice to all the respondents through speed post and YouTube. In the meantime, the petitioner is also hereby asked to provide an extra copy to the government advocate during the course of the day. List the matter accordingly after. You want any date here or after 1 week?
Lordship, after 1 week, you any date?
Date 1 week. After 1 week, you don't have any date. Oh, you are here, no?
Yes, Lordship. Prima facie are there, Lordship.
No, but in the last occasion and report was called for.
Lordship.
But yes, obviously it was asked by the additional PP to take instructions. Though PP Assam is not the party here, but obviously they're
Report, Lordship, I am appearing. First time I am appearing here in this case, Lordship.
Ah.
But that instruction, Lordship, regarding the report from the police station, then
they are not. Question is that they are not the party. PP Assam is not the party. Obviously, they can represent the OC all women police station.
Yes, Lordship, Lordship, I can take that.
Okay, then. The other carpet is for liquidity. During the course of the day goes to government advocate for the active firm. Was it?
Extra copy level.
Or what? Yes. Within a- government advocate.
Lordship,
Yeah. Yeah, because I mean, government. Oh, so that already appeared. No formal notice is required to be served on the government advocate. Full stop. বাকিখিনি একেলে। So we waiting for the instructions.
Lords,
In the same time, we are asked to issue notice to the other private respondents. also.
Lords,
So we're listing it and when it can be listed. 16th of March?
Lordship. My name may be recorded.
Yes, I have already recorded.
obligation. Well, kindly pass over for the time being. Leading counsel is late on.
Here, just a second. We have received this scan copy here.
My Lord, scan copy is
Okay.
after some time.
She is saying after some time.
May I please, your lordship. Lordship, this is
Yes, what
regular
about
bail.
9? See the
9
receipt?
case they received,
Oh.
my lord.
Lordship, this is regular bail application, lordship.
Yes.
In this case, lordship, the FIR will find lordship page number 12, lordship. And on the basis of secret information, lordship, the petitioner were in the one dhaba, Dreamland dhaba at Boragaon, lordship. And suddenly police went there as per the source information, lordship, and there was one Bolero vehicle was parked. And the source information pointed out that a Bolero vehicle and some fake currency and some fake gold is recovered from this vehicle, lordship. And subsequently, they are refreshing in the Dhaba, lordship, and the police doubt upon them and pick up, lordship. And subsequently, they are booked in this
You are
case.
going to say that they are not the occupant of the vehicle.
No, lordship. They were not inside the vehicle. Even then, they are not the owner of the vehicle, lordship. And apparently, lordship, and as per the instruction, lordship, one Islam Ali, lordship, and he is the registered owner of this vehicle, lordship. And if he is parked in the vehicle, in the dhaba, lordship, that is up to him, lordship. And another aspect, lordship, kindly come to page number, lordship, 23, lordship. 23. And
Yes.
lordship, and the notice, lordship, 48 and 47. 47 is communicate, lordship, but the notice 48, lordship, is not communicate to the relative and other family members of the accused person. And subsequently, lordship, one WT message has been issued, lordship, that is not communicated to the person, lordship, and lordship kindly looked into this bottom part, lordship, not receive anybody or any person is lordship, and this message is received, lordship. Not received, but lordship to the communicate to the relative of the accused, lordship. And there is nothing received anywhere, lordship, in this WT message, lordship. So apparently, lordship, the Bihan Kumar case is very clear, and Supreme Court one more judgment is pronounced, lordship, and regarding the notice 48, lordship. And so, my lord, on that basis, as on today, lordship, 48 days, nothing has been recovered from their possession, lordship. But one thing is, lordship, I may submit, lordship. And earlier, lordship, when Gulzar Hussain is arrested, some fake gold was recovered from other person and he was involved there. On that basis, lordship, that is the record, and he may be involved in this case, lordship. And otherwise, lordship, in this case, totally is not involved at all, lordship. So vehicle is Islam Ali, from Islam Ali, lordship. As on today, lordship, 46 days in custody, lordship. Nothing has been recovered. My humble prayer, lordship, before you, lordship.
Well, although the owner of the vehicle is Islam Ali, but at that point of time, the vehicle was found in possession of these 3 petitioners. And from the possession of, while the vehicle is in possession of the 3 petitioners, one of the petitioner is the present petitioner. Those fake currency of 199 pieces of fake currency note, 199 pieces of suspected fake Indian currency note. Total value is 99,500 recovered from the vehicle. And other 2 persons also arrested, and along with that fake currency Indian note, one fake gold with the total weight 1.391 kg was recovered from the vehicle. And at that point of time, vehicle was in possession of the 3 petitioners, and one of the petitioner is the present petitioner Guljar Hussain, my lord. And regarding my lord 41 and 48, as per his my lord statement, my lord, that there is no grounds of arrest in the section 48 notice, and section 48 notice was not served. Your lordship may kindly peruse my lord page 22 of the petition. That is my lord section 48 notice annexed by the petitioner, my lord. That is, in fact, my lord, the petitioners were arrested on 21/2026 on the same day, my lord. That WT message was sent from the OC North Lakhimpur PS, my lord, OC Bihuria to my lord DCP West, SCP Azara, my lord. So this is the WT message sent by the my lord OC North Lakhimpur to my lord OC Gorsuk, from OC Gorsuk
To not
to my lord OC North Lakhimpur. So this is the my lord WT message sent from the one police station to the other police station. And regarding the my lord, thereafter, my lord, the OC my lord North Lakhimpur police station served the notice. So the receipt, my lord, your lordship may kindly peruse below, my lord, receipt on 21.
that is
But regarding the my lord, whether they are in fact received by the relatives of the present petitioner, that is regarding that aspect, my lord, no note is there.
And as my concern, lordship, I'm sorry, lordship. And this receipt and from Gorsuk to Lakhimpur Thana, that is the police station receipt, lordship, not by the
But in
relatives
fact-
of the petitioner, lord. That is receipt, official receipt, lord.
No, but from Borsuk to North Lakhimpur is okay. From North Lakhimpur, whether any note is there that from
Your
North
lordship may
Lakhimpur, it
kindly
was
take it
sent
up.
to the relative.
Yes, yes.
That is there or not?
Yes, your lordship may kindly after some time, my lord, regarding that, if any note is there, I will check, my lord, I will point out to your lordship. Common person.
Lordship. And like, that is
That is also same.
lordship, and our difference PS lordship, it is GRPS lordship.
Achha.
Similar national lordship. And the 63 days in custody, lordship.
10, my lord,
All CD lordship.
CD not received, my lord.
You are in 63 days.
63 days.
What is the offense for?
Lordship, similar earlier matter and the pack currency and some, this is the
Achha.
pack currency notes, lordship. The investigation.
What to say?
Any
Yeah.
sort that may be fixed, my lord, for case then.
He's already on 63 days. Next Monday is not
Yes,
possible.
Monday,
will
not
be
Tuesday,
possible.
my lord.
Huh?
Tuesday.
Tuesday.
Lordship, deeply obliged.
CD not
Obliged.
issue reminder.
Deeply obliged.
10. 10.
May please, your lordship.
You have received this scan copy note here.
Can open, my lord. My lord, in this case, lordship, the petitioner was arrested. The petitioner was arrested on 22/2025.
22?
20/02/2025.
Yes.
Charge sheet was submitted on 31st of March 2024.
25.
24, lordship.
No, he arrested on when?
He was subsequently arrested.
Oh, just subsequent.
On 5/4/2024, cognizance was taken. And on 10/4/2024, that is on the very first day, NBW was issued. And on the basis of that, the petitioner was arrested on 20/02/2025. This is the second application, my lord. Earlier, lordship was pleased to reject this on 16/12/2025. Lordship may kindly allow me to start my argument from the reject order, that is at page number 101. Page number 103, paragraph number 11. I'm basically, my lord, seeking bail in this case on the ground that lordship nothing was recovered.
10, what you see? Number 10?
103, my lord.
1.
Page number 103, paragraph number 11.
Yes.
My lord, before that, lordship, I'm primarily seeking bail on the ground that nothing was recovered from my possession. I was arrested only on the basis of the statement of the co-accused person. And lordship, so far as the co-accused persons are concerned, inasmuch as lordship, 6 persons were charge sheeted, and out of those 6 persons, 5 have already been granted bail, though lordship on different ground. Page number 103, paragraph number 11. On the last occasion, also my learned senior friend was appeared in this case, lordship. The learned additional public prosecutor submitted in this regard that the case has already been charge sheeted, but charge is yet to be framed against the accused person. More so, from the FIR itself, it is seen that the petitioner is also an FIR named accused person, but he did not cooperate the IO during the investigation, and for which he had to be shown as absconder in the charge sheet. From the available materials in the case record as well as in the charge sheet, the FIR, it is seen that wife of the present petitioner is also involved in the alleged offense, and the present petitioner is main kingpin of the entire crime, who used to purchase contraband from the state of Mizoram, and then he used to distribute the said contraband to the other co-accused person for selling and distributing in other places. Further, his wife is also involved in the alleged offense, who also played a vital role in the crime. And the offense is an organized, wherein all the FIR and accused persons are involved in selling, distributing the contraband. Mr. Sharma accordingly submitted that the relevancy of the statement of the co-accused will come at the time of trial, but prima facie present petitioner seems to be the main kingpin of the entire crime. Accordingly, he raised vehement objection and submitted that it is not at all a fit case to consider the bail application of the present petition. Basically, lordship, from the opposite side, the prime argument was that, lordship, that 67 statement that cannot be considered at the time of bail. It is to be considered at the time of trial. Hearing the submission made by the learned counsel for both the parties, I have also perused the case record, charge sheet, and other relevant annexures with the petition. It is an admitted fact that there is no recovery of contraband from the possession of the accused, but from the plain reading of the FIR and material available in the case diary, it is seen that the present petitioner is the kingpin of the entire crime, who used to purchase the contraband from the state of Mizoram, and thereafter he distributed the co-accused persons for selling it to the other places. to other places. His wife is also involved in the alleged offense, and she is also an FIR named accused. It is a fact that during investigation of this case, the co-accused persons made a statement stating that present petitioner is a person who used to bring contraband from the state of Mizoram. But subsequently, at the time of investigation, it also come out that present petitioner is very much involved in the alleged offense, on the basis of which the investigation is done, and finding prima facie case against the present petitioner. The charge sheet, the case was charge sheeted against him. Thus, it is not a case that only on the basis of the statement of the accused, the case is charge sheeted against the present petitioner. Rather, it reveals that he is one of the person who is involved in the crime and fully associated with the alleged offense, though there was no recovery from the conscious possession of the accused petition. It is an admitted fact that a person cannot be convicted on the basis of statement made by the co-accused under section 67 of the NDPS Act. But during investigation, the statement of the co-accused may be the basis of investigation, though it may not be admitted at the time of trial. My lord, on the last occasion, lordship, I had submitted 4 judgments, which lordship was pleased to refer in this. All those judgments have been discussed. Paragraph number 7, 8, and 9. So I'm not referring the same judgments, though I'm relying on those judgments, but lordship, my argument so far as those judgments are concerned will remain the same. Now, lordship, today, lordship, my prime limb of argument will be as to whether 67 can be considered at the time of bail or not. I will rely only 2 judgments, one of the Honorable Apex Court and one of our High Court. Lordship may kindly come to paragraph number 53 of the first judgment, P. Krishna Mohan Reddy versus the state of Andhra Pradesh, 2025, Supremacy 865. Paragraph number 53.
58.
53, my lord. 53. Dear Lordship, after discussing all the judgments, including Tufan Singh, paragraph 53, from the above exposition of law, the following emerges. A person who is accused of an offense or named in the first information report can be examined by the police and his statement may be recorded under section 161 of the CRPC as held in so and so. A statement of an accused under section 161 of CRPC would ordinarily be of two kinds. It may be inculpatory in nature or may be exculpatory in nature. An inculpatory statement again may be in the form of an admission or confession. If such statement admits either a gravely incriminating fact or substantially all the facts which constitute the offense respectively as held in so and so, then it amounts to confession. Where such police statement of an accused is confessional statement, the rigor of section 25 and 26 respectively will apply with all its view. A confessional statement of an accused will only be admissible if it is not hid by section 24 or 25 respectively, and in the tune with the provision of section 26, 28, and 29 of the Evidence Act respectively. In other words, this is important, my lord. A police statement of an accused which is in the form of a confession is per se inadmissible, and no reliance whatsoever can be placed on such statements either at the stage of bail or during trial. Since such confessional statements are rendered inadmissible by virtue of section 25 of the Evidence Act, the provision of section so and so can be placed on such statement of an accused to implicate another co-accused. So, Lordship, my humble submission would be, so far as that statement section 67 is concerned, on the last occasion which my learned friend has argued that it can be considered only at the time of trial. The Honorable Apex Court has in this judgment clearly held that those statements cannot be relied either at the time of trial or bail. Lordship may kindly take up the next judgment, Lordship, passed in BA number 1102 of 2025. In between, Lordship, there is another judgment of Delhi High Court. I will refer it later. Before that, Lordship may kindly take up the order dated 28/7/2025, passed in BA number 1102 of 2025. Paragraph number 14, 15, and 16. It is apparent from the my lord, God. It is apparent from the case diary that the contraband seized in this case was recovered from the possession of one Prosenjit Das, who has been named in the FIR as an accused. Nothing was recovered from the present petitioner. It also appears from the case diary that even after 161 days of detention of the present petitioner, apart from the statement of the co-accused, no other materials is there in the case diary which incriminates him in the aforesaid case. The Apex Court has clarified in the judgment of Tufan Singh versus so-and-so that statement of the co-accused cannot be used as an evidence in a trial involving offense under the NDPS Act. Though such a statement may give lead to the investigating authority to collect admissible evidence, however, in the case even after so-and-so, and accordingly, Lordship, the bail was allowed. And thereafter, Lordship, another judgment, another order was passed, Lordship, in BA number 3398 of 2025. Order dated 17/11/2025, paragraph number 10 to 14. By referring the judgment of Tufan Singh, Lordship, the bail was allowed by our court. As because, Lordship, nothing was recovered from his possession. Now, Lordship may kindly take the last judgment, Lordship.
Delhi High Court.
Delhi High Court, Lordship. paragraph number 41. That is Amit Ranjan versus NCB, paragraph number 41.
Yes.
My lord, may kindly allow me to skip paragraph 41. Thereafter, lordship, conclusion part, paragraph number 43. And then, lordship, paragraph number 44 is the most relevant portion. In the instant case, the Narcotic Control Bureau has not placed on record further incriminating evidence through the initial complaint dated so-and-so, nor though the supplementary complaint dated so-and-so filed against the applicant in relation to recovery, any recovery having been effected pursuant to the stated voluntary statement made by the applicant under Section 67 of the NDPS Act 1985. CDRs between the applicant and the co-accused person per se at this stage do not suffice to establish. In that case, lordship, there were some link through the CDR, and in my case, it is not there. And the co-accused do not suffice to establish the existence of a conspiracy between the applicant and the co-accused in illicit trafficking of psychotropic substance, nor is there any document placed on record by the Narcotic Control Bureau during the course of consideration of the present bail application to bring forth the transportation of any narcotic or psychotropic substance from the applicant to the accused person through so-and-so pharmaceutical. Nor has been NCB placed on record any document to show the connection of the applicant with so-and-so pharma, whom allegedly the psychotropic substance were sent via so-and-so. Paragraph number 46, this is the last paragraph I am reading. It is essential to observe that the aspect of CDR details and alleged connection between so-and-so and so-and-so, the applicant and the co-accused person, and monetary transaction between them being in relation to illicit trafficking of narcotic substances can only be gauged at trial. In view thereof, there having been no recovery of any alleged narcotic or psychotropic substance of a commercial quantity having been effected from the applicant, and apart from the confessional statement made by the applicant and the co-accused, which confessional statement made by the applicant has already been retracted. Presently, this court is satisfied that accordingly, lordship, bail was set out. So, lordship, these are my humble ground, lordship. On the last occasion, with the leave of this honorable court, I had gone through the TCR, and lordship, in the TCR, I had gone through the statement of the co-accused person. Apart from there were 5 co-accused person. 3 has said that they have purchased things, or lordship, I was the person who had supplied drugs to them. And 2, they have not said anything. So, lordship, apart from the statement of those 3 persons, I have not find anything, lordship. Even, lordship, on the basis of those confessional statement, lordship, though my name was inserted in the charge sheet, but lordship, on the basis of their statement, no house search was made, and pursuant to their statement, no recovery was made from me. Therefore, lordship, at this stage, my humble prayer is that, lordship, all the persons who were arrested, even, lordship, the person that is Miftarul Haq, Asrarul Haq, and Abdul Munaf, from the possession of these 3 persons, everything was recovered. They were caught red-handed. Now they are on bail. They are on bail, lordship, on different ground. I'm not taking that ground, lordship. They were granted bail relying on Bihan Kumar, lordship. My humble submission is that, lordship, I'm an equal resident, lordship, may kindly allow me to go on bail with any condition. I will face the trial, lordship. That's like.
Now, what is the state of the case at present?
Lordship, charges are yet to be framed.
Charges are yet to.
Charges are yet to be framed.
Why? What was the reason? Why charges could not be framed till date?
Lordship, another person, lordship, perhaps he is still absconding, lordship.
He got bail.
No.
He got bail earlier.
No.
The persons who got bail, they are appearing or not?
They are appearing. They are appearing. They are regularly appearing. One person, lordship, who could not be arrested, lordship, and he is still absconding. And lordship, I have already crossed 1 year also, lordship. Lordship, that is my case, lordship. May kindly consider my bail, Lordship, with any condition.
My lord, here I have gone to the record, my lord. My learned colleague already pointed out regarding the my lord, rejection order, earlier rejection order, why his bill was rejected, my lord. And Lordship also already discussed about the my lord, rejection part, how he is involved in this case, my lord. Here, he is the my lord, person already mentioned, my lord, kingpin, my lord. He along with the other co purchased the contraband from Mizoram, my lord, and sold it in different places at Korimganj, my lord. Here, during the investigation method, he is not cooperating. Therefore, police has declared as absconder accused in the search sheet, my lord. My lord, my learned colleague has argued that Tufan Singh, my lord. But here, he was not arrested, my lord. Some contrabands were in possession of the accused person, my lord. He is not cooperating. Therefore, that cannot be recovered from him, my lord. From the statement of the co-accused, my lord, it is said that, my lord, 12 cartons of Yaba tablets they have purchased from Mizoram, my lord. Out of 5 cartons they have already sold. And remaining 7, my lord, 2 cartons were in the hands of my lord, another co-accused, my lord. And another 5 cartons in the hand of the my lord, accused person, present petitioner, my lord. But although several search was made to arrest him, my lord, he is avoiding arrest, my lord. Therefore, he was not unable to arrest, and the police declared him absconder as a absconder, my lord. Thereafter, my lord, police during the search sheet submitted, my lord. Thereafter, he has not appeared. NBW issued, my lord. And on 22/2025, he was arrested on the strength of warrant of arrest, my lord. Strength of warrant of arrest, my lord. And 17/5/2025 bail rejected. His bail was rejected. And next date is fixed for Kopi, my lord. That is 2013/2026 already over, my lord. That up to date is not here. Whether search framed or not, my lord. And from the statement of the my lord, Lordship may kindly peruse the statement, my lord. You look like, my lord, in the report, my lord. He is the kingpin, my lord. If he is arrested and not recover anything from his possession, that is different thing, my lord. He is not cooperating, my lord. How it will be recovered from him, my lord? You look like, my lord.
Yellow is not here,
Motive.
orange type. Or black, green type.
You look.
Yellow in green.
My lord,
No, SCA. Yellow, that's right. Yellow. Yellow.
orange. Orange.
We are searching for
What?
yellow.
Orange.
It is whose statement? One who accused.
My lord. And 5 cartons in his possession, my lord. But as he is not cooperating, and he was not unable to arrest by the police, my lord. That is there, my lord, in his possession. He is not cooperating, my lord. And 12 cartons parcel from Mizoram, my lord, all of them, my lord. All the co-accused who went there and purchased the contrabands from Mizoram, that's all are available in the record, my lord. Lordship also discussed in earlier rejection also Tufan Singh, my lord. That may be significant during the time of investigation, my lord. On the basis of the statement of a provision, it led to the investigation, my lord.
One co-accused, who was absconding, he got
My lord,
arrested now?
my lord,
My lord.
I'm sorry,
He
Lordship.
already got arrested.
No, my lord, he is perhaps
Still
absconding.
abscond.
No, my lord, I'm sorry, Lordship. I have made a wrong submission, Lordship. I apologize. Here in this case, Lordship, 6 persons are named in the charge sheet. Out of those 6 persons, Lordship, 5 are on bail.
You have
No
submitted.
person is absconding, Lordship.
One is absconding.
No one is absconding, Lordship. I was
No
the
one is
only
absconding.
person. I was the only person, Lordship, who was shown as absconding.
Acha, acha.
Lordship. I'm sorry, Lordship.
So,
I
but why Charles could not be framed till date? Record to date that date.
Same district.
You wanna visit it? Can you-
And so far as the bail orders are concerned, Lordship, of the co-accused, I have annexed, Lordship.
Their grounds are different. madam.
Different,
There are-
different.
there are
I'm not,
47,
I'm not
48,
taking that
madam.
parity.
किस तरह से है?
Evidence already started though. Evidence here, as per this evidence is already started, I think.
My lord, I don't have the information of last 2 days, Lordship. I'm sorry for that. Even Lordship, the order sheets, Lordship.
This is from Sribhumi, isn't it?
My lord.
Sribhumi, isn't it?
Sribhumi, yes, Lordship.
Lordship, may kindly peruse the order, my last order I have checked, my lord. That is 19/1/2026, man.
For copy.
I have checked my last order. It is mentioned last page, my lord. In this file, my last page.
Copy.
Your name is Asaruddin.
Yes, Lordship.
Oh, for you, it was delayed, I think.
My lord.
And I was arrested, Lordship, 1 year back, Lordship. It's Lordship 1 year, as on date, Lordship, 1 year and 10 days. And another thing, Lordship, so far as non-cooperation of the present petitioner is concerned, Lordship, I have gone through the TCR, Lordship. No notice was issued, Lordship, to the petitioner asking him to appear before the arresting authority. And recovery was, Lordship, from 3 other persons. They were caught red-handed.
Evidence part is not here.
Not
Last date was fixed for copy, Lordship. Therefore, Lordship,
No copy
And-
for you only.
my lord. My lord.
Others they have already received copy.
My lord.
It was.
And charge is yet to
Then-
be framed, my lord. If they may also argue regarding in this point, my lord, at that time of framing of charge also, my lord. The charge is yet to be framed.
However, if you get a litigation, no. Once it's gone, A2. No, ordered one. It's but both are there. A2 withdraw the unit. Actually, I have to rise by 11:45. I
Right.
have some personal appointment. So at 2, I'll sit again.
Again,
So, we'll
Right.
sit. Second half, we'll sit. Now at about 11:50, 11:40.
And my lord, I would like to point, my lord, I would like to point out, my lord, from the forwarding report, I even contacted the IO also, my lord. One note in the forwarding report is there, my lord,
Ah.
that the family members of the arrested accused persons have been informed about their arrest over telephone. However, as the family members have not appeared before the police station, a wireless telegraphy WT message has also been sent to their relatives. This is important. The response upon receipt shall be communicated to the honorable court. So regarding that, I contacted the IO, my lord, whether he has received any, my lord, communication regarding receipt of those 48 notice, any, as per his instruction, he has till now he has not collected the returnable that, my lord, report from the concerned police station, my lord.
No, but they were, through telephone also they were in.
Yes, telephone also. That is also in fact, my
But
lord,
whether on the basis of that they appear before police station, no?
uh,
They have not appeared.
no, my lord. Otherwise, petitioner.
Yes, any other submission? I have recorded the submission from his.
Yes, ma'am.
What is the other submission?
Otherwise, well, from the materials, yes, although vehicle is not, the present petitioner is not the owner of the vehicle, but at present the vehicle was in possession of these three petitioners. And Guljar Hussain is also one of the petitioners from whom all those, my lord, fake currency note along with fake gold were recovered. And section 47 notice, my lord, that is a part of the record, my lord, that is served. And regarding 48 notice in forwarding report also, that note is there, my lord, I already pointed out. And regarding, my lord, that also, my lord, noted by the trial court that up to that the response telephonically also, my lord, informed to the relatives, but that WT message from the concerned, maybe if it directly came, my lord, received by the trial court, that, my lord,
That's not.
I will have not.
Heard Mr. F. Item number 9. Mr. F. Ilan counsel for petition. And also heard Mr. Ilan petition. This is an application under section connection with submitted by Mr. Hoff that the present accused petitioner is innocent and he is no way involved in the alleged. It is a fact that on the day of incident, he along with two others were having tea in a dhaba when the police came and arrested them from the said dhaba. It is alleged that some fake currencies and some fake gold has been recovered from a vehicle which was parked near the dhaba. Near to the cover, and it is alleged that the present accused petitioners were the possessing and occupying the said vehicle from which the fake currency and the fake gold were alleged to have been recovered. We further submitted that they are no way connected. They were not the opposite. He was only single petitioner is here. No? Only one petitioner is here.
Lordship, one.
That he was not the occupant of the said vehicle wherefrom the alleged recovery was made. However, from the reliable sources, it was learned that the one Islam Ali is the registered owner of the said vehicle, and they are not at all associated with the said offense. Mr. Hawk further submitted next part. Mr. Hawk further submitted that though the grounds of arrest were communicated to the present petition through notice under section 47 BNSS, but there was no communication of the grounds of arrest to his family members under section 48 of the BNSS. He further submitted that it is stated by police that one WT message was sent to North police station by the from the OC Gorsu police station, but till yet the family members of the petitioners are not yet intimated regarding his arrest. Mr. Hawk submitted that the accused petitioner is in custody since last 43 days, and hence the IOC got sufficient opportunity to interrogate him, keeping him in custody, and hence further custodial interrogation may not be necessary for the purpose of investigation. However, he is ready and willing to extend his cooperation in the further investigation of this case if he is granted with the privilege of. Next point. Mr. Borderput learned additional people submitted in this regard. There are sufficient incriminating materials against the present petitioner, and he, along with two other petitioners, were in position were traveling with the said vehicle from where the alleged recovery was made, from where the from where the fake currency of near about rupees more than 99,000 and the fake gold of 1.39 kg were recovered from the said vehicle. It further submitted that the present petitioner may not be the registered owner of the said vehicle, but at the time of the relevant incident, the vehicle was in possession of the present petitioner and two others. Mr. Bottakul further submitted that on inquiry with on inquiry with the investigating officer, as well as from the materials available in the case diary, it is seen that the communication was WT message was sent from OC Gorsuk PS to North Lakhimpur, OC North Lakhimpur for onward communication of his arrest to his family members in view of Section 48 BNSS. He further submitted that it is also learned from OC Lakhimpur PS that he had already made preliminary conversation with the family members of the accused petitioner, but till date, there is no information as to whether they have appeared before the concerned police station or before the investigating. But the IO took all individuals to issue notice to the petition. Mr. Porter, according to his objection, submitted that it cannot be a case for granting bail to the present petitioner. Hearing this submission made by and since I have seen that there are sufficient materials against the present petitioner, and the fake gold and fake currency were also allegedly recovered from their possession. That is the vehicle. At the same time, it is seen that the IO took all endeavor to provide to intimate the family members regarding the arrest of the present petitioner. Though the family members of the petitioners not yet appeared before the investigating officer. But it is seen that the main purpose of intimating the family members of the petitioner is to file bail application before the concerned court for his release, which has already been done by the accused petitioner, and accordingly the present bail application has been filed for his release of the bail. However, in the same time, it cannot be denied that the accused is in custody since last 43 days, wherein and the IO was sufficient opportunity to interrogate the present accused petitioner, keeping him in custody. At the same time, the recovery has already been made from the seized vehicle. Considering these aspects of the case, the prayer for bail of the present petitioner is hereby granted, basically considering the length of the what also be provided to whose satisfaction this is?
CGM Kamrup Metro Lodge.
CGM Kamrup.
Deeply obliged, Lordship. Deeply obliged. Obliged, Lordship.
Yes, what is 11?
Yes, one report received, brother. Now,
You received-
earlier, my lord,
Report received.
earlier that my lord, case number was wrongly mentioned as 43/26, my lord. Now against all these petitioners, my lord, by name, my lord, specifically stated in the report, that case registered against these petitioners. Rafiqul Haq, Rafizul Haq, Abdul Manan,
Mannan. Registered.
No, no, no.
How many petitions were there? Two.
I think wrong instruction I received. I have obtained the certificate copy today. I have received the certificate of the affair. It is mentioned 43 years.
4325.
It will be push. Always 43 years.
Oh, 43, 26.
Oh,
No, what information do we have?
no, no. FIR copy I have received. I have FIR copy. The 43/2025.
43/25 under
Under
what
section
police
of
station?
61 to 3,
No,
318.
no, under which police station?
Alopati, sorry, under.
Alopati.
Police. Petitioner is granted interim on they appeared before the IO. 4 to 20 interim was granted. By order dated 4 to 20 interim granted, they appeared before the IO and cooperated. In fact, the allegation is totally false because they are not the authority, they are the villagers.
at
And-
least a CD may be called from.
Mr. S.S. the land petition. Also, Mr. P. Bot, the land report received from Alcoholics office from the scene that a case has already been registered. An FIR has already been registered against these two petitions. And the case is accordingly registered under case number 43/2025 under Alupati short PS case has already been registered against the present. However, it is submitted by Mr. Islam that in view of the order, interim order passed, interim order that the present petition, they have already appeared for the IO and their statements were also recorded in connection with the series. Next, but in view of this, let the CDB call for from the concerned police station. List the matter
On 27/3.
27/3, so it's interim be continued till next.
This CD was called for my.
Yes, CD was there.
Well, my lord, case diary not received. In this case, search sheet submitted, my lord.
Oh, such is submitted.
10 case.
12 and 14.
12 and 14.
You are appealing in both the matters. Mr. Mukhtar, you are appealing in both the matters.
Ismail.
12 and 14. Yes, in both the matters, that means the charge sheet
Yes,
is on
sir, search
display.
sheet submitted.
You were on interim in both the matters.
Yes, I am telling.
Yes, what is this CS number?
CS number, my lord, 55/26, dated 1/3/26.
1/3/26. Heard Mr. S. Mukhtar, Ilanet counsel for the petition. And also heard Mr. P. Waterford, Ilanet additional PP, appearing on behalf of the respondent. It is submitted by Mr. Court, Mr. Waterford, the case has already been charged sheeted by CS number 55/2026, dated 1/3/2026. In view of this, the petitioner is hereby directed to appear before the learned trial court below with an appropriate application for bail, which may be considered in accordance. However, till 15 days from the date of order, the interim granted to the petitioner may be extended.
Right.
So that enabling the petitioners to appear before the learned trial
Right.
court below with an appropriate application. The report received from the IO, we give to the case.
Deeply applied. 12 and 14 both, madam. 12 and 14 both, ma'am.
Both, yes.
Yes.
13, my lord, case diary not received.
Case diary not received. You are not on interim, I think.
No, my lord. No entry.
Yes, when it can be?
On my lord, 18th of March.
Pardon?
18th of March.
Lordship, little bit earlier, Lordship. Petitioner is not in interim, Lordship.
16.
16th of March. Issue reminder, 16th.
My pleasure, Lordship. Lordship, this bail application was basically based on a
Receiving
no.
case diary here?
My lord, on the basis of one GD entry, my lord.
Yes.
Earlier,
Earlier, my lord has given me the protection, my lord. So,
Just
as per my
report
instruction, yes, yes.
yes, my lord, report I have received, my lord.
Huh.
GD entry number 020 dated 31/26.
02. No,
FIR register. FIR register, my lord, FIR has been registered, my lord. I got the instruction. Oh, yes. After that. On 12/2.
no, within the jurisdiction of Abhayapuri or what?
Yes. FIR's laws.
Abhayapuri police.
In which?
No,
which-
yes, it has been registered in Abayapuri police station. So that was a outpost where she has lost the FIR.
Which outpost it comes under?
It's
Abhayapuri PS case number.
No, Abhayapuri, it is forwarded to Abhayapuri.
yes, yes.
And
So she has lost the Jogigopa police station.
Acha Jogi ko.
CD number को जाके
Yes. My lord, Abhayapuri PS case number 30 of 2026. 30.
You got the information.
Yes, I have that copy also.
Acha.
And my lord, on 3rd of March, we have been called for section 35 notice has been issued to us. We have duly appeared also. We have given our statement before the police also. And police has seized all the documents by issuing someone under section 94 of BNSS. That I have.
So you are appealing for the other side, for the informant. Pardon? Okay.
This one CD में भी call for मतलब Abhayapuri PS 30.
Mr. P. Kadilan, Council for Petition.
Abhayapuri PS
Mr.
30.
Petition PP, appealing on state response. Your MS? Hard MS A and Hussein appealing for the complainant. From the report received from the IO, it is seen that the GD entry which was made before Jogikopa PS, Jogikopa outpost as GD entry number 08/2025 dated 29/12/2025 has already been sent for a registration of a case before Abhayapuri police station. And in the same time, the learned counsel for the petitioner, Mr. Deka, also submitted that from his available information, the case has already been registered under Abhayapuri PS case number 30 of 2026 under section 69 BNS, and wherein they have also received a notice under section 35(3) BNSS and accordingly appeared, and their statements were also recorded. MS next para, MS Hussain, the learned counsel appearing for the informant, submitted in this regard that they may be allowed, they may be allowed to file their written objection, and
No,
accordingly
they have already filed.
already filed. Oh, you have already filed. change. The candidate submitted that they have already filed their written objection, but it has not been tagged along with the case record. The ST is hereby directed to tag the written objection filed by the complainant on or before the next day. Also call for the diary. Please estimate accordingly when it can.
On 26/3.
2060, so hence interim granted to the present petitioner dated 12/2/2026 be extended till next day.
Much obliged, my lord.
27. Yes,
16 also I have received the report, my lord.
yes.
My lord, Polgacia PS case number 20/26 has been registered against the present petitioner.
That's it. Section of law. What was the section of law?
You were not on interim, so we are disposing the matter here. You will be at liberty to file a case. Or we can call for, but the interim is not, the city can be called for.
Lordship can grant interim, your lordship. In the meantime, your lordship will
Yes, yes.
bring by way of filing.
We can advise, we can call for the case diary, no issue. Mr. Khan, we can call for the case diary.
Yes.
But interim is not there, so we are not extending your any interim and all, but question is that we are calling for the case diary.
A
As
section-
case has already been raised.
Under what section, your lordship? It was.
118(2).
Yes.
1182.
Lordship, in here, your lordship. The
That is the grievous hurt.
petition
section of
number
previous
1,
act.
your lordship, he is petition number 1, your lordship. The old man, your lordship,
No, this
82
will
years.
now will not come now because it is only for report only today. So we are calling for the case diary, let us see. Otherwise, the case is registered under 1182.
No, I am not saying about others, your lordship. I am only saying about the petition
Sorry.
number 1. 82 years old man, your lordship.
It will
That's,
not be
your
arrested.
lordship can consider only that, your lordship.
Okay, no issue.
One,
Heard Mr. A.M. Khan, they can also for the petition. And also heard Mr. P. Waterford, they done a petition 50 appearing on behalf of civil on the report from which police station this is? Kolgasi. Kolgasi
Kolgasia
police
PS.
station has already been received. So wherein it is reported that a case under Kolgasi PS case number 20/2026 has already been registered against the present accused petitioners under section 1182/3 subsection 5 of BNSS. Let the CDB call for. This additional PP will take necessary steps in this regard. List the matter when it can be listed.
On my lord, 16/3. 17.
17/3.
Seven.
7. Really giving a short 7.
Lordship, in here, your lordship, I am only one, your lordship, because why I am saying, your lordship, because he is an old man, your lordship, 82 years
See,
old man.
he may not be
But
arrested.
others, your lordship, I am not
He
saying.
may not be arrested, I'm not sure.
Obliged.
Now, scan copy we have already received.
Well, I have gone through that scan copy, my lord,
Ah.
but I could not find the, my lord, statements of the witnesses, my lord, under 161.
Oh,
So,
how then?
Because it is
stated that
they were attached separate.
but the statements are not there.
Separately it is there.
It is there written that name of the seizure witness is there, lordship. It is stated that in bracket attached separately.
So those
No.
statements are not there.
It is not complete, lordship.
We need this statement, basically statement
yes,
is required.
Lordship.
Because, my lord, our only contention is that nothing was recovered from us. It was recovered from the main accused. So only on the basis of statements of co-accused, police filed search. So that for that, my lord, lordship will have to examine the statements, my lord. So
Obviously.
yes,
Actually, there are 2 bikes and 4 people are there. 1 person was arrested, other 3 ran away, fled away, lordship. And on the basis of that 1 person who was arrested at the point at night, lordship, he stated that the 3 persons are these 3 persons. Out of them, 1 has been arrested, other 2 persons are absconding.
and the matter is fixed before, my lord, the lower court on 25/3. So any date before that? ma'am?
You are already shown as an absconder there.
Yes, yes. For appearance,
25-3.
25.
Commercial 22.
Yes, again. Part Mr. Esther, Zilana, Council for the petition.
Third में कौन
Also part Mr. Moses, Tekeda, Zilana, National India, respondent. And the scan copy of the TCR along with the case diary has already been received. However, it is submitted. No, 161 is not there.
Not there.
But
It-
rest remaining part of
All the
is there.
entries
All
are
the
there. Entries are there. CBN.
Accused person statements are there,
Okay.
but the seizure. Lordship may ask for
Yes.
complete CD.
Scan copy of the TCR along with the case diary is received.
Along with this.
However, on the perusal of the TCR, it is seen that there is no statement of the witnesses recorded under section 161
Oh.
CRPC of the corresponding to 180 BNSS. And thus the CD which is received by this court is not a complete one. In view of this, the registry is hereby directed to call for a complete CD with the statement of the witnesses recorded by the further the learned trial court below is hereby directed to send the scan copy of the statement of the witnesses on or before positively on or before. Your next date is on 25/3.
25/3. Any date.
When can be? Maybe 16, 17 can be?
Yeah.
16.
16 minute. Man. 16, 17.
16/3.
Mediation. Tell the matter come after a month. The mediation is on 12. Mediation. Tell the matter come after a month. The mediation is on 12.
You have your mediation is fixed on 12.
12, yes, sir.
Okay. On 5 and 6. লিখি দিয়ক না এটা খালি বাকিখিনি আপুনি লিখি দিব মই খালি শর্ট কে থৈছো আৰু both side কৰি দিব submitted by the learning council both says that the case was sent for mediation as per the date was fixed on 12/3/2026 for mediation and accordingly prayed for fixing the date after the date of mediation এটা মিলাব আৰু EST matter accordingly.
No, if it's on the first week of April, because maybe
First, maybe on first week of April, we are not fixing anything.
My lord.
Let the matter be accordingly listed, preferably first week of April. As
No,
a date
interim-
fixed by the registry.
Interim may be continued.
Interim is in both the matters.
Both the
Interim be continued in till next week. So 12/3, where is the probability is there?
If not on 12, maybe we are hoping on 18 or 20. Maybe one sitting.
May not be, one
My
sitting may not be sub.
My lord, that's all.
Lordship, with
Obliged.
regard to item number 4, Lordship.
Okay, we'll
Lordship,
see that too. I'm ready.
Received. Well, this matter may be taken up after Bihu vacation, my lord.
22.
22, my. What is that? What also access the end of the TCR requirement?
Otherwise, service is
Yes, ma'am.
completed.
Yes, ma'am.
The matter be accordingly listed. You want any fixed date here or after 2 weeks?
After Bihu vacation, ma'am.
After Bihu vacation and then a date to expect it.
I love that.
That time you wanted to submit,
Yes, Lordship,
speak.
I wanted to adjourn the matter today, Lordship. Actually, I'm handicapped because my friend, she has mentioned the matter for listing today, but she is not present.
You're for the petitioner?
I am for the petitioner, Lord. Otherwise, Lordship, the LCR has not been received. There is an office note of 2/3/2026.
None appears on call. Oh no, hard MS. You are MS?
F. Ahmed.
Hard MS F Ahmed. None comes for the petition. None appears on call for the respondent. Further, from the office note dated 2/3/2026, it is seen that the TCR is still awaited. Issue reminder, registry will do the needful, calling and do the needful in this regard. Let the matter be accordingly. Want any fixed date here or after 2 weeks?
Lordship, after the receipt of the LCR, Lordship.
Let the matter be accordingly listed after receipt of the LC. Listed.
Deeply obliged.
May it be pleased, your lordship. My lord, this
You
matter is
you
for
are
quashing of
petition.
the,
You're for the petition.
for the petition number 1 to 3.
Yeah. State is also here. But respondent number 2, Mr. JP.
Did a complainant, respond number 2.
Do you have any information?
See a
Why?
complaint case, my lord.
Yes, already did. It is in the reflected in the office note also. They are already entered into it. The last on 2, 3. Oh, yes. Okay. It's
My lord, this is a petition for quashing of the criminal proceeding. The whole proceeding we are quashing it, my lord. Here the case, the facts is about, my lord, on 10/10/2024, petition number 1 and respondent number 2 got married, my lord, to mutual Muslim rights and religious. On in the month of my lord,
some you're appearing in your offices state or personal. I mean, yes, here you're not appearing for the government side.
No.
But personal.
No, yes.
Okay.
I'm appearing for the respondent, private respondent.
Yes, private respondent number 2.
Two.
Private respondent state is 1, private respondent.
respondent number 2.
Yes. Okay.
So, my lord, the basic facts of the matter is that, my lord, petition number 1 and respondent number 2 got married on 10/10/2024. Then they were leading a conjugal life of marriage, my lord, without any. They went to the Biznor in UP, my lord. They were basically from the UP side, my lord. And on November 2024, since respondent number 2 works in Numaligarh, they have shifted to Bukaghat at their own rented residence. Then their allegation is that, my lord, since November 2024, the respondent number 1 had started misbehaving, like threatening, beating. Their allegation is that, and with their allegation is that without any information, my lord, I have petition number 1 had called petition number 2, who is the father, my lord, and he had come to Bukaghat and took away the petition number 1 along with the jewelry, cash of 1 lakh rupee and 2 gold rings, which were in my custody. Their allegation that those ornaments were theirs, my lord. That's point number 2. So, my lord, in this case, what I want to submit is, my lord, I have the grounds which I want to submit is that, my lord, I have they have since it's a retaliation proceeding, my lord. The complaint case number 1/2025 has been filed after we filed a domestic violence case in Biznor district, my lord. My lord, if my lord may peruse, my lord, the domestic violence, my lord may peruse the page number 36 of this. 35, my lord.
Page 35.
Page number 35, my lord. My lord, in this case, we have initiated domestic violence case in the year 2024 December month. Then that case was referred to the mediation center. From page number 34, my lord may very well can see the notice was issued, my lord. From 2012-2024, the case was presented, my lord. If the order is here, my lord, is reflected, my lord. The case was presented, the plaintiff Anam is present, the opposite party are absent. Let the notice be issued to the opposite party, let the file be produced. The case record is presented, the plaintiff Anam, who is the petition number 1, is present, the opposite party is absent. Let the file produce on 3/1/2025. The case file is presented, the plaintiff Anam is present, the opposite parties are absent, present the file on 7/1/2025. And on 7/1, on page number 35, my lord, the case record is presented, the plaintiff Anam is present and the opposite party are absent. The opponent Muhammad Sharik was informed about the next state via mobile number written on the record file, my lord. But this, petition number 1 has informed about the domestic violence proceeding on the previous dates, my lord, which has been on the record, my lord. Thereafter, my lord, my lord, the complaint case was filed on 5/1/2025, my lord, which is purely retaliation proceeding. They have not only filed a complaint, they have also filed an extortion case which is filed by the respondent number 2's father, my lord. They have suppressed the material in the complaint case, my lord. If I take you to the, my lord, the complaint case, which is at page number 85, my lord. My lord, page number 85 is the Anam is petition number 1 in this. Roshan Jamir Khan is petition number 2. Shabana Jamir, who has been exonerated from the charges, is petition number she's not the petition number in this petition, and petition number 4 is the brother, my lord. Now, my lord, the allegations are from, my lord, in page number 86 from bottom third paragraph, my lord. If I may read my bottom fourth paragraph, that after the accused number started frequent torture on the complaint, verbal abuse and physical torture, that the situation even got more tense when the accused number 1 did not allow the complainant to approach her and perform the basic marriage obligation. The accused number 1 intentionally neglected to perform her matrimonial obligation. Same was done at the provocation of accused number 2. That on 2011-2024, while the accused number 1 was talking to her father, namely Roshan Zamir Khan, who is the petition number 2, the complainant said to the accused number 1 that he also wanted to have a talk with him, but the accused number did not allow so. Now, again on 26/11/2024, that 1 a.m., the accused number 2, without any information, reached the residence of the complainant at Royal Awas at Bukaghat. The complainant had no information about the arrival of the accused number 2, and he was utterly surprised all through, though the complainant greeted politely, and all of them went to bed at the night time. That the whole day of 26/11/2024 was normal, and the accused number 2 behaved normally and heard all the complaints of the complainant towards his daughter, accused number 1, assured all the things will be sorted out. The accused number 2 also informed the complainant that ophthalmic operation of accused number 3, who is the mother of the petition number 1, was pending, and the same was scheduled shortly, and as such, the accused number 2 intended to have accused number with him, and the complainant, considering the urgency of the situation, agreed to the same. The accused number 1 was quite decent at the time. That the complainant booked the bus ticket for both the accused person. The accused number 1, in collaboration with the accused number, started her packing and left after the same. The main allegations are that this, my lord, that the complainant of 4/1, that, my lord, 26, my lord, may note down the date, my lord, 26/11/2024. His father came in 27/11/2024. The father had took the petition number 1 and went to his hometown. After more than 1.5 months, my lord, on 4/1/2021, he discovered that such and such items were missing, which, my lord, may note, my lord, 2 gold ring, 1 gold chain, and 1 lakh of rupees, which was in the custody of the accused number 1. My lord, which was in the custody of accused number 1. That means those items were given as Sridhan, my lord. And my lord is very well aware of the fact that Sridhan, if the girl child has been received as Sridhan, it's her absolute right in that property, my lord. Now, my lord, I want to, my lord, contradict the statements, my lord, of the statements of CW1, CW3, and the complainant, my lord. My lord, may bear from me. My lord, may come to page number 92, which is a statement of the respondent number 2, my lord. My lord, may have it. And my lord, may compare the statements of 86 page number as well, my lord. On 93 page number, my lord may come to 93 page number. On point number 6, my lord, I narrated all the incidents and atrocities of my wife upon to my father-in-law. And here, my lord, on page number 86, my lord, at bottom third paragraph, my lord, that on 25/11/20, while the accused number 1 was talking to her father, namely Roshan Jamir Khan, the complainant said to the accused number that he also wanted to talk, but was refused. My lord, there are a lot of inconsistency and contradiction between the statements of the parents of respondent number 2 as well as the respondent number 2 itself in the complaint and in the extortion case which they have filed by the respondent number 2's father. Now, my lord may come to page number 96, my lord, for a brief moment, my lord. My lord may, in page number 93, 96, and my lord 102. My lord, if my lord may compare the statements of his mother, his father, and himself itself, my lord. My lord, in page number 93, after 8 point, my lord,
Yes, you are saying that there are some
contradictions,
inconsistencies.
my lord, and
But
and it's a retaliation case.
Can this be a ground for?
No, but my
quashing?
lord, it's a retaliation case. It's a matrimonial dispute, my lord, and it's a retaliation. In the Bhajanlal clearly says it's a wreaking vengeance upon the malicious institution of the case.
For quashing.
But no, my lord, I'm just showing, my lord, it's a false case, my lord. It's a vague case. It's a vague case, my lord. It's just to the case is filed just to limit our withdraw our legitimate claim. The domestic violence case which have been filed in the year December 2024. This case was filed on 5/1/2025, my lord. It's a retaliation to our proceedings, my lord. Not only that, my lord, they have suppressed it that domestic violence case has been filed. We have got an ex parte order of the domestic violence case. We have got an ex parte of the order of maintenance case as well, my lord. My lord, and the gold chains and whatever the missing items where he has stated, these are part of my stridhan, my lord. So, my lord, there are contradiction to the statements, my lord. I will be showing, my lord, if my lord give a detailed hearing, my lord. But my lord, the fact of the matter is it's a purely a retaliation case, a vague case which they have filed to withdraw legitimate claim in the domestic violence case as well as in the maintenance case. But we have gotten the ex parte order, my lord. We have gotten the ex parte order in the maintenance case as well in the dossier, which is the maintenance case, the ex parte order domestic violence case is at page number 38, my lord. And the maintenance case ex parte order is at page number, my lord, at 50. 38 and 50, my lord. They have also filed a divorce case in their own respective area. And we, petition number 1 has gone to the Allahabad High Court and filed a transfer petition to stay, and the proceeding is stayed till now, my lord. And the order is reflected in that page number 84, my lord. My one of the ground is there is an inconsistency in the statements, my lord. That is true, my lord. But my other grounds are that they have filed this case in retaliation to our case, my lord. They have filed the case suppressing the domestic violence case in the complaint case, my lord. The said case, no criminal case has been meted out, my lord. And those are the items which were in my custody are my part of my stridhan, my lord. My lord, if I may, my lord, I would like to provide some judgments, my lord. My lord, paragraph number 13, 14, 15, 16, and 17, my lord. The judgment is page number 2024 16 SCC 35. Mulakala Maleshwara Rao versus State of Telangana, my lord. My lord, in page number paragraph number 13, my lord. The sum and substance of the present dispute lie in the father's right over the gifts that is written given by him to his daughter at the time of the marriage. The generally accepted rule which has been judicially recognized in the woman exercise an absolute right over the property, we may refer to the Pratibha Rani so and so, wherein the bench of 3 judges observed that to say the same effect is marine trustee. The characters of the so and so, my lord. Paragraph number 14, the position of paragraph number 14, my lord, the position of the woman and wife and woman being a sole authority in respect of sales, then emphatically stated in Rashmi Kumar versus Mahesh Kumar Bara in the following terms. A woman's power of disposal and independent of her husband's control is not confined to Sudaika but extend to her properties as well, my lord. Then my lord may come to paragraph 15, my lord. Notably, the position of law has remained consistent throughout since 1985 till date regarding the sole authority of the woman in respect of her citizen, as has also been held recently in Malakar versus State of Uttarakhand. So, my lord, the law is clear, my lord. These are the part of my Stridhan, my lord. Now, my lord, I would like to provide another judgment which says it's a matrimonial dispute and cost, my lords. Paragraph number 12. It's a case of matrimonial disputes, my lord. Paragraph number 12. There has been outbursts of matrimonial dispute in recent time. Marriage is a sacred ceremony, the main purpose of which is to be enable a young couple to settle down in life and live peacefully. But little matrimonial skirmish suddenly erupt, which often assume serious proportion, resulting in commission of heinous crime in which elder of the family are also involved, with the result that those who have counseled and brought about reproachment and rendered helpless on their being arraigned as accused in the criminal case. There are many other reasons which need not be mentioned here for not encouraging matrimonial legal so that the parties may ponder over their defaults and terminate the dispute amicably by mutual agreement instead of fighting it over the court of law where it takes years and years to conclude, and in that process the party lose their young days in chasing the cases in different cases. So this is the fact that it's a matrimonial disputes turning over into criminal disputes, criminal proceeding. They have filed a vague and false criminal proceeding stating just to wreak vengeance, my lord. In fact, my lord, Bhajanlal case, my lord. Bhajanlal case, my lord. In paragraph number 102, there are certain grounds where where petitioner can quash the matter. In point number 7, my lord. In point number 7, paragraph 102, where a criminal proceeding is manifestly attended with malified or where the proceeding maliciously instituted with an ulterior motive for wreaking vengeance on the accused with a view to spite him due to private and personal grudge. This is a view to spite the petitioner number 1 and petitioner number 2 and petitioner number 3 that we have filed a domestic violence case, we have gotten an order. We have filed a maintenance case, we have gotten an order, my lord. Now they are filing a CR case, being a complaint case, and now they are taking an order alleging us that we have tapped those articles, my lord. But this is my humble case, my lord. And there's also counterblast proceeding.
Cognizance has already been taken.
My lord?
Cognizance has already been taken.
Cognizance of BWA has been issued on the last occasion. Honorable Discourt has stayed the proceeding in the lower court, my lord.
DW issued? Why?
BWA issued because the we
Achha,
were
sir,
not
available
appearing, my lord.
okay. Was there any order of search warrant was there? No.
No, nothing. No mention, my lord. Nothing. Even the facts in the extortion case which they have filed is different from the facts in the complaint case and the statements of CW1, CW3, and CW6. And the statement of CW2, CW4, and CW5 are the interested witness, their colleagues, my lord. They're the respondent number 2 colleagues, my lord. They have got a phone call from the respondent number 2 stating that such and such items were missing, and they're giving a statement regardless. They are interested witness, my lord.
Lordship, what happened, my learned friends presented this argument is a completely a good argument during the framing of charge, or during the explanation of offense. Now, Lordship, this is the stage of appearance. Now, this is the stage of appearance. And after appearance, Lordship, the consideration of charge or offense will explain, Lordship. Now, whether there is any prima facie case in the criminal petition, that is to be subject matter of the learned trial court. And what is the basic prayer of the petition? Basic prayer of the petition of the petitioner is there. It is page number 28, Your Lordship. Page number 28. This paragraph is a prayer number 1A. This stated A. The impugned complaint being CR case number 1/2025 under section 296, 302, 303 sub 2 and 351 of BNSS 2023 should not be set aside and quashed. It means they are approaching before Your Lordship for quashing the complaint petition. Now, what is in the complaint petition? Kindly see, Your Lordship, in page complaint petition page 85. The relevant person 85. In page 85.
Yes.
In paragraph 2. So far, my learned friend accelerate his position regarding the article as alleged by the complainant here in this respondent, as alleged that they have the articles. That is the allegation. My learned friend accelerate his concentrate his argument on that particular point only, regarding the stolen of the matrimonial property, whatever he stated, it is up to you. Now, Your Lordship, if you peruse the paragraph number 2, there is another offense. The respondent behaves from the very beginning was aggrieved, and she often used physical torture on the petitioner. Now, physical torture is there. Where it was? It was in the subsequent, if you go through the statement of the complainant, he was examined as during the inquiry he was examined as CW1. CW1, he stated, it is page number 92. Page number 92, he stated regarding this physical torture. 92. After marriage, we led conjugal life in my house at Pejor UP about 15 days, as I was employee of the Numoligarh. Thereafter, I came here with my wife and started living together. It means the offense took place in the Numoligarh under the jurisdiction of under the jurisdiction of the learned trial court. Now, in that jurisdiction, in that place, this occurrence took place. He stated, soon after my marriage, my wife started subjecting me to physical and mental torture. She regularly used to slap me whether she get angry. This is the allegation. This is completely the prima facie material of section 115 of BNSS. BNS 115 of BNS. The criminal material is available in this complaint petition, as well as the statement of the CW. And therefore, Your Lordship, the subject of quashing a complaint petition, the prima facie is only necessary. Other things we'll discuss during the consideration of charge. Now we have that it is the premature petition. If the learned trial court wrongfully framing the charge or framing the offenses, then only he have the right to approach before this honorable court for challenging the charges framed against him. Now, your lordship, this is a preliminary. This is completely a preliminary stage of this petition, and at this stage there is the sufficient material of an criminal offence by the petitioner, and therefore, at this stage, your lordship, the quashing of entire complaint petition is it may not be justiciable, your lordship, for the interest of justice.
Or if I may, my lord, please. Sorry.
Now, your lordship, he got the opportunity that to explain all these things before the trial court when they were called for they were called for before cognizance. They were called before by the trial court.
Pre-cognizance notice. Pre-cognizance notice. Pre-cognizance.
Pre-cognizance
88.
Huh?
88.
Page 80. Page 80 is there. Page 80, not
Page 88. 88.
82. Page 80. But they were not accelerate this provision because they were not taking the chance to explain all these things before the learned trial. Therefore, my humble submission before it.
When they got chance.
Yes, that was on 18/1/2025. Before taking before summoning them. Before summoning them. Before issuance of summon to the petitioner. They were called. But they were they were not submitting anything before the trial court. It means after knowing all the facts, only in the technical issues they came before before your lords. Only this technical, whether this section will not entertain this section. This section is not in the material. The material of this particular section is not here. These are the technical things. This will discuss at the time of consideration of them. And they will get the doubts. And therefore, my humble submission before this before your lordship is that there are sufficient material for proceeding a criminal case against the petitioner. Prima facie are there, lords. Hence, my humble submission is that to dismiss this. That's all.
My lord, if I may, my lord. 3 to 4 points I want to discuss, my lord. I want to submit, my lord. My learned friend has said that it's a premature. The trial is premature because the charges are not framed, my lord. They have alleged about the section is 296, 303, and 351. Obscene Act, theft, and 351. With regard to the Obscene Act, my lord, these are the vague allegations, my lord, which they have alleged, my lord. Because nowhere in the extortion case, my lord, if I may take you to the extortion case, my lord, nowhere it is written there that any theft has been committed, any torture, because the torture and if beaten has been given, then the another section should have been put. Nowhere, no incident, no dates, nothing has been mentioned, my lord. This is just an abuse process of law, my lord. And no prima facie case has been meted out, my lord. Because, my lord, in the extortion case, my lord, there's nothing there where the theft has been alleged, my lord. Their main ground in this complaint is been theft. And after theft, we have given a threatening. We have threatened the things. Because in the statement of the respondent's mother, nowhere they were leading a conjugal life until they were shifted to Bukaghat, my lord. And in statement of CW1 and in the complaint, they have started soon after the marriage. I've started from torturing. Whether there is a contradiction or not, there's a later part, my lord. But why there are wrong statements, my lord? Why? Because there's no prima facie case only, my lord. My lord, if my lord may come to statement of CW6, my lord, which is 101, my lord. I just want to show one point, my lord. In point number 2, my lord. Point number bottom 3 line, my lord. Thereafter, 101, my lord, if my lord may have. 101. Bottom 3 line. Thereafter, they came to Bukaghat as my son works here. After 3 days of settling at Bukaghat, Anam started subjecting my son to physical and mental children. Previously, nothing has happened. They were leading a conjugal life. But in the statement of CW1 soon after the marriage, in the complaint soon after the marriage, there are so many contradictions and inconsistencies in the statements, my lord. My lord, for me, my lord, this is just an abuse process law and it's just to harass us, my lord. They were, even if they have received the ex parte order of the domestic violence case as well as the maintenance case, they have not paid us till date. They have not paid us till date, my lord. I'm suffering, my lord. We have met in the shadi.com. We got engaged itself. And from 10/10/2024 till the time of Bukaghat, we were living completely good. But due to some, the fact is that due to some physical disabilities of the respondent number 2, there was some outbursts and there were matrimonial skirmish. And for that, petition number 1 had called the petition number 2, who is the father. He had arrived. And with his permission, we have took her to our home. So there is no prima facie case, my lord, in this complaint, my lord. It's just a bogus, my lord. My lord may my lord may peruse the complaint. The statement itself narrated that yes, it's a strident, my lord. The statement is vague because there is contradictions to the statements of CW6, CW3, CW1, and the statements of in the pleadings of complaint as well as the extortion case, my lord. There's nothing else, my lord. This is my humble submission. The proceedings may be quashed, my lord, because there's nothing left, my lord. It's just an abuse process of time and law, my lord. An abuse process of court, my lord. There's nothing left, my lord. Being a girl child, I'm a bit suffering, my lord. This is a fake case which has been instituted, my lord, against me. False claim, my lord. And this is just to pressurize us to withdraw our legitimate claim, my lord. And my lord, in the Bhajanlal, it is clearly written for a wrecking vengeance, they have maliciously instituted the suit proceeding, my lord. Nothing else. I rest my statement.
Delivery order on 12th of March. I have some problem.
Deeply obliged.
Reminder. 12th of March.
May I please, your lordships? As per honorable court's order, I have taken steps, my lord, upon the respondent number 2, my lord.
You have already appeared. I think.
Yes. Respondent number 2, I have filed.
You have already filed your wakalat.
My lord,
Respondent number state is respondent number 1.
yes, my
State
lord.
is respondent.
This case, my lord, actually, what happened, my lord, in the year of, my lord, 2021, my lord, the quashing of, my lord, PRC, my lord, the matter has already been, my lord, compromised in between the, my lord, the respondent number 2, that's the informant, my lord, and the, my lord, accused. My lord, at that moment, my lord, there was a compromise, and even thereafter, after, my lord, the issuing the, my lord, they already matter. They have no whether
Now your PRC case is at what stage?
as appearance stage, my lord.
It is in appearance stage. You are
Appearance.
for quashing.
Yes, my lord.
On the next day, you do one thing. You also admit that there is a compromise. What nature of case? Case was?
My lord, 279 and 304A, my lord. In
It's accident
2021, my lord. Yes, my lord.
It is already been settled. between
Yes,
you.
yes, my lord.
Okay, then have you annexed any compromise deed and all? No.
My lord, at that moment, my lord, there was a compromise at police station, my lord. The police
itself.
station, my lord, that is not in record, my lord. I have checked the record. That is not in record. But
Okay, will
but
matter will keep the matter for
yes, my lord, for admission, my lord.
admission column.
Admission.
You do one thing. If you want, then to an affidavit on opposition or whatever, you can I mean support the case of the other side.
Obliged, please.
Pardon, Mr. Kesa. Sorry. Mr. B. Sharma, the learned judge.
13,
Okay.
17.
And you are Mr.
13 or 17?
No, you are. Your good name.
Mr. Tuesday.
Tiuddin. Also heard Mr. Tiuddin, the learned counsel appearing for the respondent number 2. It is submitted. They have already filed. He has already filed this one. The registry is accordingly directed to reflect the name of Mr. Tiuddin. The name of the deposit. Further, it is submitted by Mr. Ahmed. And the after lodging of the FI itself, the matter was compromised between the parties. However, the case has already been charged and it is fixed for appearance. In view of this, let the matter be listed in admission court. And but the respondent number 2 may file his written objection if can. This is the matter. When it
My
can-
lord, if 17 is, my lord, 17 of this month, my lord. 7.
Okay, 7.
Then there are laws. Much
You
obliged,
can
lordships.
admission column.
Obliged, my lord.
Admission
Much
column.
obliged.
May it please your lordship.
The I is for what?
Lordship, suspension of the sentence, lordship, where the petitioner has been convicted under 4 of the POCSO, lordship.
What is the term of conviction?
Lordship, 10 years, lordship.
So have you filed your any objection?
Final objection, madam. Here, before starting my collection, document kindly clear the order letter for each.
4-8. Oh, अच्छा. Why again? Actually, we later on we inquired the matter. In fact, then it was told from the concerned section that this is applicable only for the bail matters, and the rest we are distributing because there are many matters, so it has to be. So in that regard, it is most probably distributed. So that is the issue. And so you have already filed your objection.
Objection, madam. And regarding the final, madam. Only I have talked to my office manner. They also talked to my I will confirm. Then they put everything. Fire it will come in 1 2 days.
No, you have talked to with whom?
Office, madam, to our office, and office also contacted to the IU, madam. OC
Oh,
concern.
OC concern. Can be awaited for
Madam,
1 week at least one.
madam, next week, madam.
And if suppose there is, then we will we are giving a short date.
Madam,
So that suppose if it is returns, it's okay. And if it doesn't return, then we can appoint an
Yes, sir. Yes, Lordship, that
Mr. B. Chaudhary, then applicant issue, then it is applicant from the office note. it
No,
is
madam,
the-
the official no mention about that
Oh, acha,
service
acha, acha.
from my side.
Mr. Abdul is submitted with Shishram that he made an inquiry in regards to service standard. And from the office section, and it was also and the office also accordingly communicated with the OC of the concerned police station. But till date there is no report of any service of notice. Plus,
Next week, madam, any day.
acha, it's goes to court.
Mm,
With the office,
16
then
onward.
the service
16
will
onward.
waited till next set of listing.
Mm.
And the additional PP is also hereby directed to take proper instructions in that. The estimate short deduce. 16 will do?
yes, sir.
16.
I live.
Madam, I am for 20, you can 20.
Huh?
Item 20, madam. Tag me correct.
Item.
19 and
19 and
Oh, you are for 20. 20 is a criminal appeal, na?
my lord.
both of them criminal, perhaps they are in bail.
Bail. I'm on
You are on bail.
bail.
You are not convicted with 4.
They are
convicted
not
with
for that.
You are not
366
convicted with 4. 366 one. It will লিখি দিব একেলগে card. You are Mr.
Yeah,
Eh?
yeah, made, madam.
A. Ahmed. 20 number করে দিব card Mr. A. Ahmed. This is the matter accordingly on 16 along with criminal appeal number 248 of the
Bullet.
Lordship, kindly see the last order dated 31/26.
Yes.
Respondent number 2 is a police personnel, Lordship. He left his earlier place of posting, so Mr. Goswami undertake to communicate with
Whether
the.
any instructions you have received?
By
By name he is there?
Yes, Lordship.
By name.
name.
By name may create some problem. I
Minor.
don't know. If they going to represent, then it's okay. If I don't have any, you are going to represent him?
But here, sometimes because of the problem, madam, for by name when there is by name. Then you will have to send a notice, madam. He report this.
Otherwise, you have already sent the notice.
No, Lordship, notice unserved.
Notice return answer. But a police personnel, how notice can
Minor.
return answer? Notice cannot return answer because he is a police personnel, isn't it? Debodatta, APS Deputy Superintendent of CID. So he is
Left his earlier place of posting, Lord. He went to some other place. Lord.
he cannot. His notice cannot return answer. In fact,
So Lordship, PP may communicate with the personal Lordship as per last order.
By name, madam, otherwise.
but at this stage, do you think he was the informant? Na? Then say what to do. Because otherwise he is a police officer, so his notice generally should not return unserved. His place of posting may be different now because he may not be posted in the earlier place of posting. Yes, Sharma, can you help us any in that regard?
And this is one, but this is also another, there is also another point, madam. Let's say, my lord, whether it is charged or not. That is required.
Scan copy was called for. Scan copy was called for.
Scan copy was called.
Not
Charge sheeted.
No, we have no information. We have no information. So far, our information is concerned, charge sheet not yet filed.
No, one order in the last order, not last order, 1612 order is there.
Fine.
In point number 7, for consideration of the case projected by the petitioner, appraisal of the record of GR. Record of GR case number 15223 of 2018. Corresponding to CID case number 28 of 2018 would be necessary. Now you are saying that it is not charge sheeted. But already
CR
GR
number,
CID number is also. This is a
CID police
no, CR number.
CID PS case number, Nikki, this is.
CID case.
Acha, so it may be CID PS.
CID.
CID. So what to do? You take instructions or what?
Present status.
So he is saying as per his instruction, till date,
Fine.
no charges is late. Huh?
If charged is not contained, then it is required.
Yes, CD of CID case number 28, 2018 will be required. That is already called for, but
Fine.
in regards to 2, what will do?
My lord, they may for the another time, my lord, they may
Oh yes.
spending money.
From where you are saying that it is return answer,
Record we have seen on last occasion.
last week. Issue remind. No. In once it is TCR is called for and then again CID, I don't know
Fine.
what is going on. What to call for it?
Then also resistors may be allowed to take against the respondent number. Let's see what resistors be directed.
And in your capacity also, you can take just instruction because he was appointed as a CID superintendent at the
Yeah.
point of time. And he may not be there at that now at present. But definitely he may be posted somewhere, if not retired. That may help us. Otherwise, he will
Yeah,
take
Lord.
steps, definitely will take steps. But here, once it is written that scan copy of the TCR, and
Fine.
now he is saying that it is not a charge sheet. Status call for, I think. And now TCR means what TCR? We don't know now.
Then no
Because
charge.
CID case number 28 of 2018 may be the case number.
Case.
Maybe the case.
Or they may take a step, my lord. Then I will take instruction, my lord, regarding the my lord, status. If it is my lord charged, then also may call for action. If it is not charged, then
So you have come for washing.
washing.
21 Mr. A. P. Sarkar, and in the office, the petitioner is hereby directed to take fresh steps to respond. At the same time, the additional Mr. Sharma is also hereby asked to take necessary steps. And in regards to status of the case, as to whether the case has already been charged,
Here in
or to call for the CID case number 28 of 2018. Let's say matter accordingly. Let's see, after 2 weeks, we are listing matter.
the date may be fixed.
What will be the
Otherwise,
date?
Any
And
date.
date is also there in 24th of March.
We'll take instruction regarding the status.
Yes.
23
Yes, Mr.
May it
Kalita.
happen. This petition filed for the suspend of sentence, my lord, as did in NI case, my lord. In revision case, my lord, already notice was issued, my lord.
At that point of time, you have not filed.
No, my lord, later, my lord, IA was received.
Now, whether NBW has
No.
issued against him, what
No.
is the position now?
Position, my lord, next date was fixed on 20, my lord, 20 March, my lord. That criminal,
For his appearance.
yes, my lord. For criminal revisions, I have submitted, notice was issued, this order I have already submitted. The next
So
date,
till date, he is on previous
yes,
date,
yes,
till date,
yes,
or any NBW issued?
no, any.
On the last occasion, yes, Sharma, you made a prayer most probably.
Yes, my lord, they have cleared you.
You made a request.
Your lordship's order, there is similar matter.
No, it's okay. I'm not on that. Now they made a request. Why?
Yes, my lord. But that is.
On the last occasion, you made a request for pulling the matter. I don't know why.
Madam, as per section 148, madam, NIF, madam. There is provision, madam, at the time of the madam appeal. Minimum 20% is to be paid for admission.
Oh,
First, that was madam argued by my friend, madam.
That was in appellate court, my lord. And it is not mandatory, my lord.
that I'm not also not a bit confusing whether in that revisional stage that is required or not.
Yes.
Obviously, at the appellate stage, it
There
is
is
required.
mentioned in the
And now see 148, 20% 148 is though in some cases the Honorable Apex Court had held it is maybe mandatory.
Not no.
But as if you go by the statute, seems is directory, not the mandatory. And there is a fluctuation provision is also there. 20% may relax to 10% also, depending upon the situation. But whatever revisional I have not found, I don't know whether it
what is your not revision? What is the appeal stage that is there?
yes, that is there. It is there. Appellate stage 148 is there. 8 is there. Anyway, we are. This is we can dispose of.
My
Okay. So PP, who is the other party?
other
But
party
in notice, in criminal revision, my lord, notice.
Notice already
Yes.
issued.
Mistake.
not this part.
But Mr. M. Kalita, the last it's an application in section 4A, bracket 2 of PNSS for suspension of sentence and granting bail submitted by Mr. Kalita that against the impugned judgment and order dated 8/11/2024 passed by learned SCGM M. Bojali in NI case number 50 of 2021. The petitioner preferred an appeal against appeal before the learned session judge, which was numbered as criminal appeal number 22 of 2024, and by judgment and order dated 1/11/2025. The appeal was partly allowed and the petitioner was directed to pay compensation amount of rupees 7 lakhs to the complainant respondent number 2, which the positive. Accordingly, he submitted that till the disposal of the connected revision petition, which has been filed against the order of learned session judge, comma, the execution of impugned judgment and order, as stated above, may be stayed or be suspended. Further, he submitted that the petitioner may be allowed to remain on previous bail till now. Why the question of why the question of his bail comes here.
My lord.
Why the question of bail is here now?
So, my lord, otherwise, my lord, NBW,
But the appellate authority has already modified the sentence.
yes,
And now you are to pay only the compensation. I mean,
no, my lord, 3 months punishment was given.
yes,
That is,
the imprisonment, there is no such.
3 months
Because,
already,
because otherwise 6 months imprisonment was there.
yes. Then, my lord, modified to 3 months in default.
No, not modified.
Modified, my lord. Yes, my lord, in my revision, my lord, page 38, my lord.
Now see, as I don't know, from your cost title, it seems.
Oh, my lord, cost title,
Just a
page,
second. Here,
page
here
2.
it is seen that petitioner was directed to pay compensation amount of rupees 7 lakhs to the complainant respondent number 2 in default of payment.
Yes,
to undergo in default only 3 months.
yes, my in default, my lord.
You are not find any sentence.
Wanted they also confused about
In default, my lord.
It is only default.
only default.
Yes,
So stay of the execution will suffice.
My lord.
There. I mean, there is no such sentence now.
Yes.
Sentence is not there. Only competition part is there. And in default, there are 3 months.
3 months.
But earlier 6 months was there.
Yes, my lord.
6 months along with 7 lakhs.
7
That
lakhs
6 months has already been modified.
modified, my
So partly appeal is allowed
Yes.
to modify the sentence and 7 lakhs. So we stay the proceeding.
lord.
Stay the execution.
Yeah, in the last
Yes,
38, page number 30, there are 27 clearly.
Yes,
The accused applicant is directed to pay compensation amount of 7 lakhs to the complainant as well as in default
in default
of
payment,
payment under
simple in stay, my lord.
Stay political. Okay, well, disposing your eye.
Obliged.
May I please, Your Lordship, a correction of the order, Your Lordship.
Yes, you said yesterday. Yes.
Your Lordship, the name of the father was wrongly mentioned as Abdul Rahman, Your Lordship. It should be Azmat Ali, Your Lordship.
But this is from where it has come, Azmat Ali?
Your Lordship, while drafting the bail petition, Your Lordship, inadvertently the name was wrongly mentioned as Abdul Rahman, Your Lordship, in the
But
bail.
now to enter your entire thing, this your identity of the person will be changed now. How?
Only
This is not, it cannot be now.
father's name, Your Lordship.
Father's name to identity.
Yes, Your Lordship.
Father's name is the main identity. You can say there is a case number may be different, police station may be different, but your identity will be different now.
But
We are not passing any order. Was what was the Mainuddin, son of late
Abdul Rahman.
Abdul Rahman, we have passed any order. We have passed the order on the basis of your petition wherein you have identified, disclosed the identity of the person as a son of Abdul Rahman.
Yes.
Not at Azmat. You cannot be.
After, Your Lordship,
You
as per
cannot be allowed.
Your Lordship, after getting the order, Your Lordship, 15 days time was given to appear before the trial
Yes,
court, Your Lordship.
obviously. Huh?
Because of this order, Your Lordship, the name of the father, Your Lordship, it was not being possible. That's why.
It
Your
is
Lordship-
not the fault of the, it is not the court
yes,
question.
Yes, Your Lordship.
Obviously, but still then if some police station number is, but you are not now challenging the identity and the identity of the person will be changed. It cannot. What is gone is gone. What to
Yeah, Your Lordship, next part.
No, so now see, you, me, myself, you, he is identified by whom? To your father.
Yes.
Because still we are living in a patriarchal society. So identity, Abdul Rahman, maybe Abdul Rahman, maybe spelling may be wrong. That can be, it's okay. Azmat Ali and Abdul Rahman is far different.
Quite different.
Why different? When enter identity of the person will be changed.
Your Lordship, now what to do? Your
What to do? I don't know. You may file a fresh application. That may be one of the, yes, Sharma, what she can do now. What can you suggest her? Anything? Fresh application for earlier order can be annexed, and then the as the identity was so it was otherwise. Or if he appears also, why he is not appearing?
Your Lordship, after this order, Your Lordship, the name is wrongly recorded already, and then 15 days also has been expired, Your Lordship. On 2nd of March, the 15 days expired, Your Lordship. Now
You have a ground for subsequent bail application. Because of that reason, your thing is not accepted by the IO. And you can write the application for correction was also cannot be made because because of the yes. So in this matters can
One para maybe environment
one maybe environment may be there, and then you can file a fresh. Otherwise, what to do? I can understand
Yes,
your
yes.
problem now, but that cannot be allowed. Son of Abdul Rahman and Ajit Ali is
that is
quite quite contradictory,
what?
quite different. Identity will be changed. Anyway, I heard
S. Nazin.
Kutul.
My name is not in the.
Oh, not me.
Yes, not in the call. S. Nazin.
Heard MS Najin, done it counsel for the petition, and also heard distribution in another edition. It's an application. If I file the rejection order, you want to withdraw it. What to do? Better to withdraw, I think. Better to withdraw, I think, because again, an adverse order may pass.
Yes.
No? Better to withdraw. Besides some technical irregularity, she wants to report. Prayer allowed. The petition to file a press application for bail.
Liberty to file a
It may be it may come up before this court.
Yes,
You may consider, we'll see to it.
the liberty to
Pardon?
liberty be given.
No, this I
Oh,
for I
yes,
too, I
yes,
cannot
yes,
pay
yes,
liberty.
sorry.
Now is fine. Your time period has already expired, so you could not appear due to those and these reasons. That can be brought. We'll see. You are always at liberty. I asked the registry to list a list numbers of matters. Accordingly, they listed a list numbers of matters because of my appointment. A personal engagement was there. The very urgent also. I have to give. Tomorrow our working day. I don't know what
We'll
will
have
be
to
there.
come,
Huh?
we will have to come, my lord.
Or tomorrow also.
Already engaged in a number 18.
Court number 18.